Welcome back to the JDG, everyone. This is our final meeting for the academic year, and we have the pleasure to be joined by Eleni Rethymiotaki, who is a professor of sociology of law at the University of Athens, and is here today to present her paper entitled Source of Law and Legal Pluralism in the European Union. Eleni, thank you very much for accepting our invitation. You have the floor.
Thank you also very much for the invitation. And I have a PowerPoint. I start to share. Can you see it?
Yeah.
Okay. So let's start by a quick look to the main points. First, the perspective of social theory, then polycentrism as a political ideal for European integration, legitimation problems of political power due to the vertical and horizontal diffusion, the theoretical debate about European Union's law, a dialogue between complex network paradigm and the critical scholarship, the challenges of constitutionalized rescaled political powers and reimagining a post-national citizenship, and finally, the relationship between European Union's legal order and national legal orders. Here the question is legal pluralism being transformed from the sociological hypothesis into a normative principle? Now let us first start from the perspective. The central question for this subject, which lies between political and legal theory, and especially political theory, which is rather the first who joined the discussion, who opened the discussion, especially in the field of international relationship. And there have been many approaches, diverging or complementary. Now, the question which persists still today is whether European Union can function as a political and legal entity that strengthens the European states and at the same time preserve their historical conquests, democracy, rule of law, and rights. The epistemological perspective of this paper is one of political sociology of law. Here, European integration, it's an ideal case for reassessing the following two basic theorems of sociology of law. The one is, the one hand, the two hypotheses, the first was the complex interaction between law and politics, and on the other, the persistence or even the revitalization of legal pluralism during the first quarter of the 21st century. Now, the first hypothesis about concerning the relationship between politics and law is that legal rules, institutions, procedures, professions, scientific knowledge, they are shaped through the correlation of political forces, and conversely, they have a decisive influence on them. However, this interaction should not be considered in a simplistic, one-sided, unilateral way, but in a complex one. At the heart of the relative debate lies, of course, the discussion of law and democracy. The second hypothesis of sociology of law is that law is bigger than state law, but not all kinds of norms are legal. Here, the assumption is that the state has never fully achieved to conquer the monopoly in the production and application of law. Diverse normative grids, transnational or subnational, cross state laws boundaries, tend to reshape the hierarchy it sets by developing competing or complementary relations with it. Why then European Union constitutes a rather ideal case to test the validity of the above-mentioned cornerstone hypothesis for sociology of law? European integration has undermined both de jure and de facto the fundamental axiom that the state concentrates political power to an absolute degree and thus play a hegemonic role in the production and application of law. While the legal political entity of the European Union may remain fluid and unclear for an unpredicted period, its creation and evolution demonstrate eventually that states' hegemony of political power and legal monism have been relative and historically variable. As long as European federal state is not established, something which may never happen, the relationships between European Union's polity and law and its member states' legal and political system remains under constant scrutiny. The question of European sovereignty is still a strongly debated subject, as well as the way European polity has influenced the sources, the legitimacy, and the rationality of modern law, which is inextricably linked to nation state. European integration as a political phenomenon reopens the question of the relationship between law, nation state, and society, which was entrenched at least until the end of history in the late 80s. European Union became an institutional matrix that takes and implements crucial decisions and policies in all sectors of government. Some of them, like guarding the territorial borders or the fiscal balances, lie at the heart of national sovereignty. A new political scale thus has emerged, neither at the same level with its member states nor above them. So the first question is, does European Union tend to become a post-national example of polycentric polity, where political sovereignty is shared or pooled between a plurality of political centers, or do multiple but insufficient both claims and efforts to reconfigure European Union's political legitimacy show a persistent crisis of parliamentary and popular sovereignty as manifested within national political and legal systems? Given the above-mentioned political ambiguity, can the thesis of absolute or even relative autonomy of the legal from the political still be taken for granted? The second question is whether and to what extent has the bipolar law politics been restructured, and in what way has changed in the context of European Union? How does the principle of rule of law function in case of European Union? The adventure of European Constitution has shown the impossibility of relating automatically the political hybridism of European Union to the legal paradigm that was historically associated with nation state. Although law has been systematically used as tool for the economic and political convergence of European societies, it did not fill the political void. The insufficient degree of political mediation of the conflicts that European law attempts to solve had the side effect of low legitimacy of the project. And third, last but not least, as a legal phenomenon, European Union's great endeavor of progressively harmonizing the member states' national legal orders has transcended the state-centric legal model. European Union's legal order not only coexists with the national ones, but they are mingled together in an unforeseen way. The coupling of multiple legal systems had created a complex European normative economy. If one assumes that the production and application of law is inherently characterized by a tension between a centripetal and centrifugal force, then the third question is, how does this dichotomy work in the construction of European legal order and its relation with national ones? Some speak for evolution of European legal order towards a transnational network of legal orders with complex cyclical relationship in which European and national courts and other institutional or even extra-institutional actors play a key role. Some others, however, tend to accentuate the triggers and cracks of the same project. I hope. Can you see now the next?
Yeah, the second slide, yeah.
Very nice. So let us come down to the political question and examine polycentrism as a political idea for European integration. Here the question is supranational, national, or transnational. European Union is constantly evolving unpredictably and in a highly controversial way. The older and for many years powerful conception in the political field was the neo-functionalist approaches, first functional and then neo-functional, which put forward the idea that European Union will sooner or later transform itself in a rather automatically way into a supranational entity. On the contrary, the neo-realists' view was to consider European Union integration process only an affair between states, whose importance in decision-making grew in proportion to their power. Both of these poles share the classical conception of sovereignty, of course, that sovereignty is an absolute power to exercise supreme authority located in a particular level of power, the government and the parliament emanating from it. Now, the third way was and still is the neo-institutional and we may say constructionist approaches, which try to overcome this dichotomy national-supranational by reinterpreting the very concept of sovereignty. Sovereignty can be shared without losing its substance. This is not something self-evident. They advance the metaphor of a European polity and by demonstrating the leading role of European institutions, which developed a life of their own, and the creation around them of a transnational political field in which state actors, European institutions, and private actors are intervened. It is a field of political action that mediates cooperation and competition, both of it, between European member states, with a certain relative and varying degree of autonomy. The existence of extremely dense institutional zones surrounding European centers of intergovernmental negotiation shows that the European Union as a policy field has a hybrid character lying between the two extreme poles of the state-federal dipole. The inherent tension between centralization and decentralization of political power is therefore fluctuating. According to the above, European Union has been evolving thus towards a multi-level governance structure, a network of political hubs within which member states continue to play an important role, but no longer directly control important areas of activity. The concept of shared or pooled sovereignty conceptualizes how one state can share a portion of its sovereignty without losing it. However, the flow of political power from the state is both upwards and downwards as information and resources are transferred and policy implementation is coordinated over a wider area than national territories. The portion that state loses is not transferred to a level above, but it is diffused and liquidated. This implies a cyclical network type organization, a political power distributed over many levels which interact. The redefinition of sovereignty is described by political science as a transition from government to governance. The term expresses a political practice and a concept in favor of the decentralization of state power, where civil society and the market involve in the exercise of power. In the early years of 2000, this approach prevailed also in the European Commission when it issued its famous white paper on European governance in an attempt to overcome the democratic deficit from which suffered a growing political way in the immediately preceding decade. Must we then overcome the dichotomy national-supranational, or there are considerable reserves to it? From the second decade of 21st century up to now, European Union is facing a polycrisis. Some members have contested its legitimacy. Its institutional capacity was tested by the Greek economic crisis. Its jurisdiction has been questioned in case of refugees crisis, and Brexit has shown that there is indeed an exit option available. Strong tendencies of polarization between North, South, West, East make it more and more difficult to visualize European Union as a political network consisting of node states of varying degree of power. On the contrary, they reflect both the intensity of the competition between member states and the institutional dynamics of their cooperation. A recent study comparing the efforts of European Union to efficiently cope with the above-mentioned crisis draws a conclusion that European Union tends to govern by emergency, sliding towards politics of last resort. In any case, the role of nation states remains important. Of course, how strong each state is always depending on its position in the international political power distribution. The supposed omnipotence of the modern state was nothing more than an ideal type theoretical construction that unified a multitude of institutional variation due to the different historical development of each country. Today, due to the fluidity of political formation of the European Union and institutional innovation, it is easier to accept that state sovereignty is a matter of degree. Up to now, European states have been more or less actively involved in economic and political regionalization. National political systems, also more or less, function as exclusive arenas where social forces are expressed, debated, and confronted, and where processes of democratic control of political powers have been establishing. But whereas this is a political ideal discussion, from the other point of view, we have legitimation problems of political power due to this vertical and horizontal diffusion of it. Let us accept, for the sake of the argument, that especially during the first decade of 21st century, European governance became a form of consensual co-management of state sovereignties that reinforced the position of its member states, given the geopolitical balance of power of that period. But did the vertical and horizontal diffusion of political power have any side effects on the legitimacy of political power of European Union itself, as well as of its member states? Many scholars have underlined that the operation of governance networks have raised an issue of democratic legitimacy and accountability, while it was not clear that they were the right answer to the regulative problems of late modern European society. Excuse me, to be sure. Okay. So we come down to legitimation problems, and you are right. And this here we have three main sources of problems. First, the European Union may indeed function as a relatively autonomous field of political power relations, but it relies on a post-democratic consensus. The inevitable conflict stemming from the power asymmetry of member states remain visible, yet not negotiated. If through European law, the asymmetry increases instead of decreasing, then unification through law may de facto function as a postmodern mechanism of legal acculturation, a discussion which reminds of us the legal transfer debate. Instead of achieving the legal convergence of European society, their mere denial of conflicts reinforces their political and legal divergence. Secondly, the more political decisions are taken at European level, the less social conflicts are expressed. This can only be expressed at national level to the extent that the institutions of representative democracy are functioning. But this severely affects the legitimacy of political systems and the mediating role of law, because it seems that it can no longer influence the dynamics of relation of sovereignty with its categories and hierarchies. Thirdly, the diffusion of political power has changed the balance of the three powers, causing great ambiguity about who decides what and to whom deciders are accountable for each and every decision. The executive was strengthened, resulting in the erosion of popular sovereignty. The development of formal and informal governance networks violates the principle of equality and deactivates democratic control processes. At the same time, the phenomenon described as comitology has aggravated the democratic deficit. Committees have proliferated, assisting the European institution in the production and implementation of policy. They are staffed by technocrats, quasi-national representatives, who are legitimized by reference to their scientific expertise rather than the political position they express. Instead of polygon of political forces, EU is more like a labyrinthine system of governance that, by combining intergovernmental networks of technocrats with networks of dubious representativeness, acts practically uncontrollable. In conclusion, European polity oscillates between a tendency towards polycentrism and multi-level governance, and on the other hand, a tendency towards selective supranationalism and technocratic elitism. The above-mentioned problems explain why today conflicts, debates in public sphere and political theories focus are on the implications of European integration in regard to parliamentary and popular sovereignty. How can the capacity of the parliament that its members are elected and represent the people be asserted? How can citizens participate in political decision and to continuous democratic dialogue? This is an ongoing discussion. Now, let us come to the questions regarding more closely law. Here we must first remind that there has been a crisis of law, which was associated with the emphasis of welfare state law first by the 80s, then gradually by the 90s we have the deregulation and then re-regulation effort, and at the end of 2000 decade there was obviously a new balance of the three regulatory poles, state, market, and civil society, and many said that there was a reshape of legal rationality as the hegemony of state in legal production and application has been shaken because the normative power of the market and private companies has been strengthened, a phenomenon referred to as legal globalization, but also the role of civil society, NGOs, as well as social movements with cause lawyers and so on became important. It was the French Jacques Chevalier that said that it was at a national level that law lost its transcendental power and symbolic superiority, legitimated by its reference to reason and democracy as the optimum way of organizing collective life. The above described changes have been accelerated and magnified by the pairing of politics and law in the European Union. It was at late 90s that Christian Georges stressed the role of Rechtspolitik of European Union, and later Neil Walker, who underlined the necessity to constitute a special legal theory in order to understand European Union's legal originality inextricably linked to its political one. Today, retrospectively, one may say that there are two main theoretical approaches of European law, which debate about the past, the present, and, most interesting, the future of law, European law. One is the postmodern paradigm of complexity, which describes and conceptualizes legal change by proposing the network metaphor for law. Luhmann, Ladeur, Teubner, Ost, Kerkhoff, Thornhill. They propose a broader, a macro-social transformation with a European Union political and legal constellation being an outstanding example. The other paradigm consists in a cluster of critical approaches started to criticize and contest aspects of European legal integration, the reactive role of law, and to investigate transformative possibility, rethinking the role that may or may not assume law in European Union. Rasmussen, Jorges, Somek, Weiler, and Neuvonen. From 2010 and so on, a series of successive and enduring crises in the European Union has strengthened the critical approach. The critical discussion regards mostly rule of law crisis and concern that crisis management tend to become a new normality for European Union. Now, according to the paradigm of complexity, first, European Union law is characterized by polycentrism, that is multiplication of sources such as European institutions, institutional networks, public authorities, private professional bodies, and in between hybrid nature institution also. Secondly, contractualization, that is extensive use of contractual techniques, including all forms of soft law, liquid law. And third, reflective rationalization, that is development of self-correction mechanism and self-evaluation techniques. In this way, communication between multiple legal orders that mutually determine each other, although they are at higher and lower levels, is achieved. Law may function as a complex but cohesive system for coordinating collective action, learning to correct and adjust itself to ever-changing conditions. According to critical approaches, the same phenomena are interpreted as, first, the strengthening of the technocratic character of law, because it is increasingly produced less and less by politically elected and more by those appointed with reference to scientific expertise. Secondly, hybridization of sources, because hierarchy is being destabilized and forms of normativity, the classical forms of modern law, are being confused. And finally, we have fluidization of law, as the same time is overloaded and unable to ensure the predictability of social behavior that Max Weber had talked about. Thus, powerful pressures are exerted to modern law, undermining both its rationalizing organization and power of collective life and its mediative institutional capacity to power relationship. Semantically, one example combines polycentric politics with network law, while the other identifies issues of democratic sovereignty with the weakening of mediating capacities of modern law. Which of them should we choose? Certainly, we can no longer afford to overcome the question by just resorting to the positivist argument that an empirical foundation is needed to support our ultimately normative choice, whether it is acknowledged that it is normative or not. Instead, the best solution would be to turn to social theory of law, democracy and rights, in order not only to criticize, but also to dare to ask what might follow in the field of European law, to come up with a new approach to the questions of what is possible in the field of European law. Retrospective reflection on the adventure of European constitution and the constant normative tension in the relationship between EU legal order and national ones can be extremely useful in this direction. Now, what do we have to learn from the effort to constitutionalize the rescaled political power and the effort to reimagine a post-national citizenship? From the perspective of a political sociology of law, the relationship between European legal order and states' legal order is an open question to be explored. In the state context, the autonomy of law from politics is seen as relative and historically changing, as we said, as it is the balance between tendencies towards centralization and decentralization. On the one hand, the adventure of European constitution has shown the impossibility of relating political hybridism of European Union to the legal paradigm that has historically been associated with nation state. But as much as law has been invested as a tool for achieving the convergence of European societies, it did not fill the void of the political. The insufficient degree of political negotiation of the conflicts that European law attempts to mediate has had the side effect of law legitimacy of the project of rescaling law's concentration space. On the other hand, European legal order is characterized by a constant tension between a unifying and divisive dynamic in its production and implementation, which is reflected in its relationship with national legal orders. Their coordination is developing into a complex system of cyclical communication, which is made up of their competing and complementary relationship. Now, as far as European constitution is concerned, It is clear with hindsight that it was not reasonable to expect that European Union will have a properly speaking political constitution. European Union has not been constituted as a political community. No social force has claimed its democratic organization, regulating the relationship between the majority that governs and the minority that opposes it, while the main political actors remain its member states. Nevertheless, European Union already has had a legal constitution, that is, a set of rules with increased formal force, not only because it has declared itself through the mouth of European Court of Justice an autonomous community of law that is superior to national one, but also because this stems from the powers and competencies that member states themselves have given to its institutions. European Court of Justice began the process of constitutionalizing, that is, it developed the principles of union law as a synthesis of the law of member states. Based on the theoretical assumption of legal pluralism, a legal order can indeed function without its states, but not without a field of political power, albeit a relatively constituted one. Indeed, although formally the European Union does not have a self-sufficient political power, it nevertheless functions as a field of concentration of public power. The economic governance that emerged from the consensus of state powers. The power to organize and operate the single market and later single currency and fiscal policy is being transferred almost completely to an opaque point above or between member states. It is therefore now a question of democratizing a political power that is exercised on a larger scale than the one of national territory. It was in this context that the theoretical debate on a post-national constitution was opened in conjunction with the always open public debate for the deepening of democracy at national level, as Habermas or Neil Walker talked about. In this field, there is, as you already know, a monograph series in Oxford edition of constitutional theory, which it is a collection which really actualizes this ongoing debate. And the debate goes on. And finally, let us concentrate on the relationship between European legal order and the national one. The theoretical question is whether legal pluralism from a sociological prescriptive hypothesis is transformed to a normative principle. The relationship between legal orders is characterized both by a unifying component and by a conflicting dynamic. Legal pluralism is being then transformed from a sociological interpretative hypothesis into a normative principle governing the unification of European legislation. Legal theory has primarily contributed to this through the confrontation of the hierarchical model with an interactive one, the debate on the supremacy of one order, either the union or the national one, or the autonomy of both. The influence of the antagonistic and complementary relationships that developed between the European Court of Justice and the national Supreme Courts was also decisive. The former has, through its case law, developed the basic principles, the pillars of the autonomy of European Union law. Depending on the stage of development of the European Union, the Court of Justice has on many occasions moved on the razor's edge between law and politics, making full use of legal arguments. This started the process of constitutionalizing European Union rules as a counterweight to the sovereignty of the member states, against which it defended the economic freedom of individuals. And the constitutional and supreme national courts, either directly or indirectly, attempted with more or less success to redefine the relationship between the European order and the national one. The main reason for this was the conflict between the rules of national constitutions and primary community law. The German Federal Constitutional Court, for example, considers itself competent to decide whether there is a conflict or not. It has also made a condition of the supremacy of European law that it protects fundamental rights no less than the German Constitution. On the contrary, Greek highest administrative court, Council of State, has a limited scope of intervening, certainly because it's not a constitutional court. The competition between courts is to some extent to be expected, but it also reflects a deeper conflict between legal epistemological paradigms. It contrasts the hierarchical paradigm consistent with the state-centric political model and the interactive paradigm associated with the political and institutional innovation of the European Union. If it is ruled out that the Union legal order is a kind of imperial law, like Somek says, then its coexistence with national ones presupposes mutual recognition and communication, as McCormick had already from 1995 said. Both the Union and the national judge are called upon to co-construct the legal orders that are a priori defined as operating simultaneously in the European legal area. The coexistence of autonomous regulatory systems and judicial institutions means both cooperation and conflict. According to one view, coexistence boils down to an overlapping consensus, an agreement that both parties will consider the interpretation of common principles in the light of others' arguments, as Rawls or Ginsburg have put it. Judges elaborate principles that resolve the conflict, and citizens must refer to more sources of law to adjust their behavior. Nothing guarantees an a priori either that resolution will always be possible to the end, or that complete legal certainty is to be expected. In the final analysis, the construction of the European legal order is the construction of a network of communication between several orders whose interdependence requires mutual adjustments, constant coordination, and constant renegotiation. Acceptance of plurality and complexity implies acceptance of uncertainty. Indeed, according to the postmodern epistemological paradigm, this is yet another indication that the pyramid of modern law has been turned upside down, resting on a spike and culminating in a seat where more parallel hierarchies end, like Ost and Michel van Kerkhove said. But if we do not wish to throw the baby out with the bathwater, we must also consider how dangerous variation in interpretation can, after all, prove to be for the constitutionally guaranteed rights of citizens, especially under the influence of political pressures in the current context of restructuring the relationship between law, economy, and politics. Thank you for your attention.